Jeffrey, we're ready.
All set.
Okay, so this is the Holyoke City Council Charter and Rules Committee meeting taking place on Monday, April 10th, 6:30 p.m. at Holyoke City Hall, which is 536 Dwight Street in Holyoke. We're also streaming on Zoom and on Boxcast, part of Holyoke Media. With us today, we have Councilor Murphy Rombaldi, Chair of DGR. Today, Committee Member Councilor Murphy Rombaldi, and President of the Council and Committee Member President Todd McGee. On Zoom, joining us today, we have Councilor Linda Bacon, Councilor Will Puello, Councilor Kevin Jourdain, and with us as well is Attorney Jane Mantolesky. And let me make sure. And that's it. So with that said, entertain a motion to take up item 1.
Second.
You want to take all three of them together? So, sure. So
Motion to take up item 1, 2, 3 as a package.
all in favor?
Aye.
Any opposed? So a motion to take up item 1, 2, and 3 together as a package. These are orders put in by Councilor McGee. The first one is that all road and sign issues, including ordinances, be sent to the Public Safety Committee instead of Ordinance Committee. The second is that all employment-related ordinances issues be sent to the Public Service Committee instead of Ordinance Committee. And the third, item 3, is that the Public Service Committee be renamed the Public Service and Human Resources Committee. So these are all essentially name changes and also where orders are going to be referred to. From the last conversation, the last time we took it up, which was last month, there was a question from Councilor Bartley around what to do with orders of our ordinances, or if there should be sent somewhere specifically, sort of like what are the legal things that are happening behind this. And I spoke with Attorney Bissonnette, and of course he can correct me if I'm wrong, but essentially we decide as a body where orders can get sent to. And these, even if they are ordinances, doesn't mean that they can only be referred to ordinance committees. We are all elected legislative body, and ordinances changes can be taken up at any committee as long as the required votes take place. So the question is, of us as a committee tonight is if we want to make these changes to our committee / council rules, really. So yeah.
Yeah, I'm gonna let you, as the maker of the order.
Councilor McGee.
So, legal reached out, I think it was Mike Bissonnette, yeah, it was Mike, regarding changing some things that might go to another committee to try and help ordinance, in essence, alleviate some of the congestion and all the stuff that they're doing. And these were the recommendations coming from Mike, saying these are things that you might want to consider to move around, allow other committees to kind of share the wealth in order to not have everything just dumped in poor ordinance. So these were the suggestions. I filed them on behalf of Mike, and now we're just here to see, you know, what is the best approach as a body. What do we want to see, and where do we want to put stuff? So that way ordinance isn't here till 11 o'clock, 12 o'clock at night, that they only can take up certain items on one night. Can it be done in public safety, public service, or something else who may not have as much of a workload? So that was the reasoning for this.
Thank you, Councilor McGee. Councilor Bacon, I see your hands up.
Thank you, Mr. Chairman. I just wanted to offer some information for the consideration of the committee tonight relative to these orders. I did a review of the jackets, and as of now in the Ordinance Committee, we have approximately 20 traffic-related orders in the jacket, whereas in public safety, they have about 60 traffic DPW orders in their jacket. And we have been moving things fairly timely, and if people have been requesting particular attention on the traffic matters. So I think we have our arms around that fairly well. Certainly it's up to the body how they wish to configure committees, but it looks like public safety is actually overburdened in this regard at this time. And as it comes to salary-related orders, there's less than a handful in the ordinance jacket right now. But again, I'll defer to committee and council as a whole. But I would also let you know that the amount of referral to committee relative to marijuana that was extremely heavy for a very long time is very much lightened at this time. We did the 3 public hearings for the extensions for the special permits. And other than that, we have no pending public hearings relative to marijuana. So that appears to have leveled off. So I do appreciate the consideration of the committee in terms of the workload of ordinance, but that's what I can offer to you from the review that I did before the meeting tonight. Thank you.
Thank you, Councilor Bacon. Councilor Murphy-Ramboletti.
Thank you, Chairman, Chairperson, Chair. No, I think that Councilor Bacon makes a great point, and I think for me, the main thing that I feel warm to is because with employment-related issues, there are a handful in the jacket, but I also recognize that there's a lot of items that end up in the jacket that need to be addressed before certain things get addressed related to employment. And so what ends up happening is it does take a little longer. And, I think these improvements make these changes make a lot of sense. And I actually really appreciated hearing how many have been referred to public safety that are related to traffic. So that's really helpful to know. But I do think that even though there's only a handful of certain things, I think there's a lot that just gets put into the Ordinance Committee jacket that if we could take some of these off, especially onto committees that maybe don't have the volume, I think that would just make a difference in streamlining the process. So I think that's all my thoughts for now. Thank you.
Thank you, Councilor Murphy-Ramboletti. Councilor Jourdain.
Yes, thank you, Mr. Chairman. I don't have a strong opinion about the item too much, but I would only ask just from a process perspective. My opinion would be, and I'm just asking a question, I know I happen to sit on this committee, as you do, Mr. Chairman. I don't recall the law department, I don't know, maybe they had a meeting before they went to the president about it, but it would seem to me you'd want to sit with the chairman and say, hey, we're really noticing it appears you're overburdened and we have these concerns. What do you think? Do you think we could take this off and that off and put it over here and then talk to the ordinance committee membership, maybe get on the agenda of an ordinance committee and say, do you think this could work better or this could work worse? And then at that point, once we have a conversation about it with the ordinance committee, then you reach out to the president to say, hey, can you file an order about making these changes? It seems like we missed a step. I don't know, I guess I haven't talked to Linda about it, but I don't know if the chairman of ordinance, did the law department reach out to you about these concerns? Or, because this hasn't been on an agenda of the ordinance committee. Thank you.
Councilor McGee.
Yeah, it's not, I understand Kevin's point or Councilor Jourdain's point. This is from a series of meetings that we've had in Charter and Rules as well as Public Safety where comments have been made of, can we move things to different committees? And it's come up several times, of which Mike has been at the majority of those meetings. And I think this is a reflection of him responding back to hearing it over and over. So it's not as if someone is saying, oh, you have to do it. It's been a series of comments, Councilor Jourdain, where people had said, well, if it's too much in ordinance or too much in finance or too much here, how can we move it around? And these were some of Mike's suggestions to that. That's all it really stems from.
Any other counselors? I'm gonna say. Okay. So thank you for everyone's comment. We don't have to vote on all of them together. They can each have separate, due to Councilor Bacon's point and other points that were made as well. Councilor Givner has their hands up.
Sorry, I have to sneeze. Give me a second.
Bless you.
Thank you, Mr. Chair. I just wanted to add to that conversation just slightly. It's my understanding that things have been spread around that don't require actual ordinance changes, because ordinance was so busy with so many things. I don't think the amount of traffic things in any committee that are getting shuffled around really reflect a huge workload burden, because a lot of them get addressed simultaneously when the city engineer chimes in, or the chief of police chimes in or something. So I just wanted to add that tidbit. It doesn't seem so much of it seems like what Councilor McGee was saying, I guess I'm just reiterating, in that there's been a lot of talk about how can we move things around to different committees that don't require the attention of actual ordinance changes. Why burden ordinance with things that can kind of be dealt with in bulk in other committees? So I just wanted to add that. Thanks.
Thank you, Councilor Givner. Actually, before recognizing you, we have been joined by Councilor Givner on Zoom and Councilor Israel Rivera. Mr. Rivera, your hands are up.
Thank you for recognizing me, and thank you all for your time. So for me, I guess with regards to this order, and I'm not on that particular committee, so I'll speak from the outside. I actually like it. It makes sense to me, right? Because the feeling is that things that are public safety should actually go to public safety, and then they can go to ordinance if there's an actual ordinance that has to be fixed or made or amended with regards to what it is to public safety. If that's the case, then what's the purpose of having a public safety committee? Everything that comes up at public safety or comes into my jacket, I try to put it up. If you look at all the meetings that I've had at least 10 to 12 orders attached to them. There are things that are there from before my time, and I've been trying to pull them out too and hash them all out. I guess for me, where it comes down to it is, it only makes sense for public safety to kind of handle these issues. And when it comes, hopefully we're able to get to that point where orders that are filed actually go into the places that they should go to, because there's a reason why we have committees and groups, at least in my opinion. But if not, then, maybe we could just create 3 committees and then have everything done that way. So that way we don't have so many committees, because I'm gonna be honest with you, sometimes it feels like there's no point with regards to my committee, because some of the things do not come to my committee even though they should. But that's my piece. Thank you.
Thank you, Councilor Rivera. Anyone? Councilor, go ahead. Councilor Jourdain.
Yeah, Mr. Chairman, I think I really like the points that Councilor Rivera made and Councilor Givner made. Maybe that is the thing to help us out here, is that we have these discussions and move, and I think Councilor maybe Murphy Ramboletti made the point too, is we have these discussions and they go to those respective committees, and then if there's no ordinance required, that's the end of it. But if there is an ordinance requirement, that's the point that committee would make the decision to transfer it over. Maybe that's the way to work it out. I think those are actually good suggestions.
Yeah, I think that's been the intent from the start.
Councilor Murgy.
Yeah, I think that's been the intent from the start. If it needs a new ordinance or a change, then it would have to ultimately go to ordinance, be put in legal form. But to spread the workload over 2 committees, proper committees, and then, it's like another way of shuffling the cards around.
Thank you. Councilor Bacon.
Thank you, Mr. Chairman. And I'm fine with that, and I don't think it requires changing any of the descriptions. It's just a matter of making the decision in council where it goes in the first place. Thank you.
Thank you. Councilor Rivera, your hand's still up. Last time? 3, 2, 1.
No, that's an error. That's an error. I'm trying to put it down.
Thank you.
My bad.
I was just going to ask, I'm glad Councilor Bacon brought that up because I was just confused. Is this something that needs to be like added into the rules, or is it something that we just kind of, the president is kind of leading where things get referred to?
I mean, in our rules now, it does say stuff in the sense of what should go to what committee. So that way, once again, as Councilor Mantolesky said, is we have many times, it's supposed to technically go to finance. We ship it off to public safety because they're having an emergency meeting and we can just get it done. So we move things to other committees. But if we're saying, hey, we want to have certain things go there, it probably would be best to amend our rules to add this stuff. But in maybe a footnote or something saying, once again, if it still needs an ordinance, you send it to ordinance to get a final. However you guys want to do it, I just think we should update the rules to meet this if needed.
Thank you, Councilor McGee. I think I'm trying to find the rules come up, but I believe in our rules and it has to go through ordinance in order to get legal form eventually. So either way, I think, so I'm on the page where we should put this into our rules just because we want to keep that consistency going, beyond Todd's time as our president. But we're
Is there an end game?
institutionalize these sort of rules. So that's sort of where I'm at with it. Councilor Bacon, your hand's up.
Thank you, Mr. Chairman. The only point that I would make is if something's going to end up in ordinance, I think it's better if it starts out there, because at this point in time, for things like speed humps, even signs, and the engineer has to go out and review, it's a fairly long timeline for people who are waiting. So for things that we know will end up in ordinance, I think it's sort of adding a layer of meetings for things that we know will end up there. So that would be my only comment, to be careful of that so that we don't make people come twice on the same issue, sort of like we merge things for planning and ordinance for public hearings.
Thank you. Councilor Murphy-Ramballetti.
It's actually a really good point. That sort of makes me like, I don't know if that means that if it has to go through ordinance, or there's just, I think this starts the question of like, what are certain things that are required by ordinance that maybe don't need to be required by ordinance through the city? Like, I think maybe that's what is coming up for me, because with that point, if you're going to have this start with ordinance, like the whole goal is that we are alleviating some of the responsibilities from ordinance. So if it does still need to go to ordinance, it kind of feels like that defeats the purpose of what the initial goal of the ordinance of this was. But I don't know.
I would comment on that real quick. So I'm also a member of ordinance, and so are Councilor Israel Rivera and Councilor Givner, and Councilor Jourdain and Councilor Bacon. But as far as like the sort of that, both Councilor Givner and Councilor Rivera are also in public safety, and I think what this would do, if anything, it would give it so that the long conversation can be taking place in those smaller committees, so that when it comes to the bigger committee, it's not necessarily should we pass this or not. It's more of like, does this language make sense within our ordinances? Okay. Which is, I think, is a different conversation to have.
Okay, so then I guess I'm saying this isn't going to be like duplication of the exact same conversation in public safety as it will be in ordinance? Because then that's just double the time for all of us, and that's not really the goal of the change, right? Tell me if I'm wrong, because if I am,
So, I mean, ideally, I can't for sure say that people will not bring up the same points and have this kind of conversation. But I think just going back to the point I just made, I think it's different conversation to be had at the public safety, where they're looking at public safety as a whole, to then being put in front of the ordinance committee. Does this ordinance make sense with other ordinances? Is it in the right section? Is it in the proper form as far as like the words themselves? But I hear you. I mean, that's part of city council, a lot of repetition, I feel like. So, Councilor Rivera has their hands up. Councilor Rivera.
Hey, give me 1 second. All right, thank you. So I guess for me, to the point that the councilor made, Councilor Bacon made with regards to, and Councilor Tessa Murphy-Ramboletti about possibly having to do the work twice. I see that, but then again, I don't, because technically, like, a committee does the work and then they report out to whomever it is, right? So if we're actually working as colleagues, right, and we're functioning as a body that's working together, whatever that comes out of public safety should be reported out to ordinance, so that it does not have to go back through that process all over again. So when ordinance gets the piece of material or whatever it is, all they have to do technically is go through the process of whatever amendment is made or whatever law needs to be made or something needs to be changed, because hopefully they were updated on what was already happening in the process at public safety. Like, ideally, if things are working the way they're supposed to work, that's how it should be. Now, if we're gonna assume that it's not, and we don't actually trust that we're gonna all do our due diligence, then I can see the purpose. But I don't know, for me, it's like, then what's the purpose of having a committee? Like, if that's the case, then don't have the extra committee, put everything in ordinance, or put everything in charter and rules, or put everything in DGNR, where at the end of the day, you can have these open conversations, because they actually have all the power to actually make decisions and do things. The other committees don't, and they're just, I guess, doing smaller meetings, I guess, whatever needs to be done. Thank you.
Thank you, Councilor Bacon.
Thank you, Mr. Chairman. So the place that I'm stuck on is that in order to get things in ordinance form, we have to do the work of reviewing the order in ordinance and then put the request to legal for the legal form. So the role of committees historically has always been to do the work in committee and make a recommendation to the full council. From time to time, we have made a referral from one committee to another. It's the exception, but every once in a while it has happened. But because there's so many orders in public safety already that relate to traffic and DPW, about 3 times more than is sitting in ordinance right now. And based on my review of the jacket in ordinance, I don't think we have things that have been sent to ordinance that won't need an ordinance. If I'm mistaken on that, I would happily send those over to public safety. I mean, it's not a matter of wanting to have things that don't belong in a particular area, but I believe most of the things in the jacket are things that will need an ordinance change to complete them. And usually the citizens are looking for those to happen fairly quickly. Thank you.
Thank you, Councilor Bacon. Councilor Israel Rivera, your hand's still up.
So again, like I said, most of the stuff that has been brought up, I put it up immediately. If something gets filed this week, I file it the next Public Safety Committee meeting. So whatever orders are in the public safety jacket probably has already been addressed, and more than likely is just waiting for further information from either DPW or the city engineer, like it has happened on various occasions. But at the end of the day, like I said, if that's the case, then we could dissolve the committee and then everything can go to ordinance. Because at the end of the day, it feels like we're just playing quick little games here and there with the public safety committee, because whenever there's real stuff that has to do with real stuff, because it has to do with ordinance, it doesn't get addressed in public safety in the committee that it should be addressed in. Because if it pertains to public safety, it should be addressed in public safety. Ordinance should just stamp it at the end of the day, right? It should go to the ordinance and they should take the word from the colleagues. You do not have to have the conversation all over again. I don't understand why it can't be sent to ordinance, where ordinance can then request the language. Why would we have to do a whole new conversation about the language and all the other stuff if that was already if it was already had in public safety? Or are we saying that public safety does not have the power? The counselors in public safety does not have the power to be able to have these conversations? Because if not, then again, I will reiterate, what is the purpose of having these committees? Because if there is no power in these subcommittees, there is no reason for us to have them if we can actually make any real moves in these committees, right? At the end of the day, it just like, it's cool to learn this, but at the same time, it leaves me like flabbergasted a little bit, because at the end of the day, you'd think that as a public safety committee, you'd be able to make certain decisions and have certain influx or say so with regards to the public safety within the community. Ordinance just writes laws, and I totally get that, and I agree with it. Like I have no issues with regards to that. But with regards to public safety, the idea is that you're able to unpack and actually have the conversations around these things. And ordinance is not the place for that, to be honest. But I mean, historically, it seems like that has been the place. And historically, it seems like this is a practice that we've been doing. So ultimately, I can understand why the change is peculiar and it's different for some people. But at the end of the day, we need to get to a place where we're doing city government in a way that's effective and efficient. And we have not been doing that for a very long time. There's pockets of it where it's good, and there's pockets of it where we're really, really bad. So we need to work on, as a council, trying to do the best that we can in our positions to try to show the community what it is to actually do city government in the way it's supposed to be done. And I'm trying to do that to the best of my abilities as I learn through this process. Thank you again.
Thank you, Councilor Rivera. Councilor Givner.
Thank you. Thank you. I just wanted to also just piggyback on that a little in a different direction. I wonder if this is a question for Attorney Bissonnette, because I am under the impression that we can have discussions, make recommendations for legal language, which would then have to be approved in ordinance. So my question is that true or not? In which case, that would kind of change how I feel or what I'm asking.
Attorney Bissonnette, did you hear the question?
Well, right now, under your rule, I think it's 9G. Yes. So your rule 9G right now would require any ordinance to go to the ordinance committee for its review. You can make an exception if you wanted to send, for example, all traffic-related and public works-related ordinance matters to the public works, public safety committee. But that also would require that if you had ordinances coming out of any of these other committees, those proposed ordinances would have to go to the ordinance committee before it goes to the full council. That's the way the rules are right now.
Okay, thank you, Attorney Bissonnette. I guess I just wanted to clarify that, I guess. Yeah, I just wanted to clarify that it makes sense for us to have discussions in other committees about things, and if they require ordinance change, recommend legal language that would then be sent ultimately to ordinance for approval. I would also like to mention that in my case, it's always understood that if something's going to need an ordinance change, that it should go to ordinance. I think we're specifically talking about things that we don't think need an ordinance change because, like with traffic, if there's already a stop sign and we just need another one, it just needs to get like sent to DPW or something. Or, I think we have a good understanding of what requires actual ordinance changes. So I just wanted to be sure that I'm thinking along the right paths before I make arguments to support something I don't understand. So I really appreciate that, Attorney Bissonnette.
Thank you, Councilor Givner. Anyone else? I just wanted to say real quick, we are 13 elected officials to be the legislative body. So I think all 13 of us are tasked with creating the laws, creating the ordinances. And if that comes from any committee, I'm okay with it. Unfortunately, our rule 9G does says it has to be referred to an ordinance committee. But at the end of the day, that's just a rule that we have within our city council. I have not been told otherwise, that there has to be a specific committee that ordinances have to go through. Like, my understanding is that us as a body, we get an ordinance or we get an order, we go through it, we make sure that we do the 3 readings that we have to do, and then we can vote on it regardless of what committee it goes to. But because we do have that role in our city council rules, regardless of what changes we make with item 1 and item 2, there's still going to have to be an ordinance committee step. So just wanted to make sort of that clarity. I also think it's not something we're going to be figuring out tonight, because I think there's other points that were brought up and other conversations that still need to be had. So I'm wondering, the table.
Second.
Okay, so motion to table is item 1, 2, and 3. All in favor?
Aye.
Any opposed? Okay, so items 1, 2, and 3 are tabled.
4, 5, and 6 are the same.
So 4 and 5 are around the voting requirements, and 6 have to do with getting counsel or legal opinion for the council.
So motion to take item 4 and 5 as a package?
Sure. So second, motion to take up item 4 and 5 as a package. All in favor?
Aye.
Any opposed? So item 4 is a communication from Councilor Jourdain regarding a legal opinion on June 1st, 2021. And then item number 5 is an communication from Attorney Jane Mantolesky, supplement to legal opinion on voting requirements. Do we want to read the whole thing? I can.
Could we share the screen perhaps, and maybe share the?
Yeah, can we put up on the?
Oh, Jeffrey, can we put up? We'll go into item 4 first. You put it on the screen.
Already working on it.
You're the best.
So item 4 was a legal opinion, June 1st, 2021, by our city solicitor, Lisa Ball, regarding City Council Rule 66. It used to be Rule 66. Talking about quorum and what it means to have 2/3 vote. I feel like I should just read this whole thing.
What?
Hold on.
Let them.
Or they should just speak on it.
There you go.
There it is.
Cool. So with that said, I did see Jane, attorney, here, if they wanted to speak on these legal opinions.
Hello.
Hi.
So I'm not sure why. I think Councilor Jourdain should probably speak to this one, item number 4 that was submitted. I think he had put it onto the City Council's agenda at their last meeting. So I believe he is present, and I'm not sure if he wanted to speak to that being there.
Councilor Jourdain, I see your hand is raised.
Yeah, sure. I'm happy to speak to it. So this opinion from 2021 Because I think we have a couple issues, legal questions here at play. And as we get into this, I'm of the opinion that we need to do a lot more research together and have some dialogue to figure this all out. It is somewhat complex, no doubt. And I have definitely a number of opinions and suggestions tonight. But I want, in thinking about breaking down the issues, we have the first issue, which is the contention in the most recent legal opinion, which is this notion of when we say we're taking a majority vote or a 2/3 majority vote, is it of the entire membership or is it of those present and voting? And so the legal department recently came out with a new opinion, which was obviously the subject of some discussion. This was relative to the issue about when we got to a point where there was, 2/3 vote needed. They came up with an opinion in light of the fact that Councilor Anderson Burgos could no longer vote, was an 8-4 vote sufficient. They maintained that in fact it was, on the premise that they felt that present voting was, that there was ambiguity in our rules and that present voting is what the rules should be. And so they alluded to, in the footnote, to this opinion from June of 2021. And I am bringing this to everyone's attention that this question has been asked and answered already from the law department. So you have the city solicitor has signed 2 different legal opinions, essentially saying 2 opposite things. In the first legal opinion of 2021, she's asked, what does 2/3 mean? Is it of just who's there, or is it of the entire membership? She answers the question, it's of the entire membership. That for a majority vote, it's 7 votes. And for a 2/3 majority, it's 13, it's 9 out of 13. This is right what it says. So essentially that was my position. And she says that the reason I'm changing, if you read the footnote in the second opinion, she says, I'm changing my prior opinion because the rules changed from December 11th, 2017 to the new version from June of 2022. And what I'm pointing out is the rules haven't changed. The numbers changed because we reordered the numbers, but there hasn't, the wording from 2017 and 2021, and for that matter, 2022 to today, is still says crystal clear that we have 2 things going on here. We have the former Rule 38, which became Rule 8K, which says that an ordinance has to have 2/3 of the full council voting in a recorded vote. Because we have some votes that don't require a recorded vote. As a matter of fact, the default in the charter says that a recorded vote is not necessary automatically unless 3 members request it. That's in the charter. So what we've said is that no, anytime, because ordinances are important, we're requiring that all ordinance changes be recorded in a recorded vote, not a voice vote. Okay, so now you go to this opinion here, which is the definition section, which used to be Rule 66. We've now moved that over to Rule 1. And it says the exact same thing. And it says in that, all votes of the council or any of its committees requiring a 2/3 or more supermajority shall require that same supermajority of the entire membership. I mean, it's as crystal clear as it gets, as far as I can see from that sentence. And the city solicitor at that time was asked, what does that mean? So if you read I'm looking on the screen here, if you read the paragraph that says, the final line of Rule 66 addresses votes of the council and any of its committees requiring a 2/3 vote or more supermajority specifically requires the entire membership, which, as explained above, would be all 13 members. That's been my point. That is my point. I agree with her in this 2021 opinion. So I'm just wondering what happened to this, because the rules didn't change. It was unambiguous in 2021. Somehow it got ambiguous a couple of weeks ago, and that is allegedly the genesis for this second opinion, that because there was ambiguity or perceived ambiguity, we needed a second opinion. And I'm suggesting we should follow the 2021 opinion, and I think they had it right the first time. So that's where we're at. Again, we have multiple issues here this evening. We have one issue, which is it present in voting, or is it the entire membership? We also have the second issue, which is, can the council require a 2/3 majority for the passage of an ordinance? That's a separate issue. Both good questions to discuss. I tend to be of the opinion that we need to do a lot of homework and research around this together. But I think why I filed this is this question's been asked and answered, and I'm at a loss as to what happened in the second opinion. So the second opinion, I suppose we can wait until we start talking about the second opinion. So I'll stop there, but I'll offer a few suggestions of thoughts to think about with that opinion. But I want to point it out and get it here for one and all, that if you haven't had an opportunity to read the first opinion, this is the first opinion. And this came from 2021 on this topic. So that's why I'm pointing this out to the body. And, this question has been asked and answered. Thank you.
Thank you, Councilor Jourdain. Any other councilors speak on it? Okay. Attorney Mantolesky, are you? Go ahead.
Hello. So I think that, this, what Councilor Jourdain just mentioned is a perfect, segue into the supplemental opinion that came out on April 4th that I actually wrote. And I think that it is a good starting point for the council to start looking at how some of the language in the rules is in conflict with our state statutes. And where that conflict lies is often in the requirement for certain, the voting requirements on certain matters. After our, which date was it? The March council meeting that I appeared at and presented, I really did take to heart a lot of what everyone's concerns were. Councilor Jourdain, Councilor Bartley, Councilor Vakins. I really wanted to take that to heart, and I really wanted to make sure that I was presenting the most accurate opinion of knowledge that I had. So I did a deep dive again, and I wanted to deep dive into this issue and say, well, what really is required under the statute, and are these rules in conformity with that? And the April 4th letter that supplemented the most recent opinion from City Solicitor Ball was as a result of that research that was done and that deep dive that we did to make sure that the City Council is acting pursuant to or in compliance with statute as well. So I am happy to speak about that and the supplemental opinion that I have provided. With respect to what was it, a June, I think it was June, hold on. The June
1st.
21 opinion. Yeah, June 1st, 21 opinion. I think from my conversations, again, I was not here at that time, but from my conversations with Attorney Ball, City Solicitor Ball, we did, we looked into the background of it, and this was, I believe, a rule, just analyzing that specific rule, Rule 66, because I believe that the question at that time was specific as to that rule. So when this opinion was asked to be analyzed, I believe there was a look at that rule and what it requires based upon the reading of that rule specifically. So I believe that when we did the second opinion in March, I believe it was March of 23 this year, and we looked at the rules in totality, the new rules that were ordained in 2022, the law department came to the differing conclusion that there was a difference in the language based upon that Rule 66 versus the new rule in the 2022. But again, I think what really needs to be looked at here now are these rules in compliance with statute? And if they are not, then something needs to be done by the city council to make sure their rules are in compliance with statute, lest they be subject to possible legal challenge at some point.
Thank you, Attorney Mantolesky. Anyone else? Councilor Jourdain.
The first thing I'm going to say is appreciate everything Attorney Mantolesky has just said there. I first, though, am at a loss because the premise of the second opinion from March was that there was ambiguity. So there wasn't any ambiguity, though, because the statement was made that the rules changed. And I'm at a loss to understand how we can read the two words. The only thing that changed was the numbers, but the words are exactly the same, as I pointed out. So I don't understand how they could say that, and by the way, it should be noted that the second opinion from March makes no reference to Rule 1 at all, that there's actually a definition section. Only mentions Rule 8K, never mentions Rule 1, as if Rule 1 didn't exist. And yet we have this opinion right here, which makes crystal clear it's the entire membership. Now, the law department could argue, well, it shouldn't be that way because it conflicts with X in state law, perhaps. That's a separate argument. But to say that there was ambiguity as to what our rule is, I don't see how anybody can fair-mindedly look at this and read Rule 1 and read Rule 8K and say that doesn't mean the entire membership. Okay? Because even the law department, as recently as 18 months ago, said that's exactly what it means. All right. So as far as the second opinion goes, I think I've made my point on the first opinion. The rules didn't change. So to me, my concern is, why are we even having this discussion? Okay? If the discussion is, let's talk about, hey, we've come to the opinion that we think some of your rules are in conflict with a state law, then I'm willing to have that discussion with the law department and sit down and go through this and review cases and laws and, let's do that. Something's come up. We have new information. But that wasn't the way it was explained as to why this all of a sudden came out of the left field. Because the thing that it felt to me was, if that was the legitimate concerns, and those are legitimate concerns, it just felt like to me that what I was witnessing was how the context of how this got brought up, okay? And it was in the context of saying that the rule was ambiguous. And it all related to a vote was coming up short at that time. And it was not discussed with the council like we're having this nice discussion here, okay? This is the forum. When you're gonna make a major change of this nature, we should have a huge discussion about that, okay? Because the implications of not having the rules based on the entire membership, and why this council has been so particular about that over the many, many years, is because of two basic premises. One, we require all members to vote unless you have a conflict of interest. We don't allow you to sit there and say you're present, okay? We require everybody to vote. We don't allow people to duck votes. That's number one. And by having the rule about entire membership, it requires, there's no reward for ducking votes, all right? Because you only hurt your cause. Second point, this is not in the public interest to allow that to be just based on who's present and voting. And why we've had this rule for so long is because of the fact that certainly I can speak for myself, but I think I can speak for a great number of my colleagues, because I've served here for quite a long time, have been very concerned that we want to make sure there is a substantial, true majority of the body in favor of something. For example, if we have a majority of the entire membership, then that's 7 votes, not 4-3, okay? Because now, if we don't require our rules to be the entire membership as they plainly read in Rule 1 and Rule 8K, then you could have votes of passing with a majority with a quorum of 7 being 4-3. We've never allowed that in the past, okay? Never. And as far as the 2/3 go, it was 9, and before it used to be 10. So you had, when we were 15 members. So not, if you had a quorum of 7 people, you would have a vote conceivably of 5-2. That could be 2/3 now, based on this new opinion. That is a huge, huge change for this body, okay? And I don't believe the public is well served by that rule, in this counselor's opinion, because one, it encourages people ducking out on unpopular votes. It encourages conflicts of interest, and people say, well, I have all these interests, I just won't vote. But by you not voting, you're actually helping to get it passed. For example, just what we had happen the other night, right? First, Counselor Anderson Burgos is told he can vote. And for the first 2 rounds and evenings, he was voting on it. Whatever happened behind whatever, in the end, he in the 3rd round of evening doesn't vote. By not voting, he actually helps it get passed. So now it's 8-4, it's adopted. And I just use him as one example. This could happen in a situation where, and I know there's a number of people that are pushing maybe to have city employees be on the city council, right? And we'll hear arguments like, oh, well, don't worry, because, if there's city employees on, you can't vote on that various area. Well, if they don't vote, then it lowers the total of the required votes to have something be passed. And that now helps people. That has not been our tradition here. That has not been our rules. So that, I hope, most people would agree it should be based, just as our current rules say, based on the entire membership. Now, I'm willing, and I'm keeping an open mind. I just received Attorney Mantolesky's recent April 4th opinion. Today's the 10th. I got it 5 or 6 days ago. I'm pouring through it. We had Easter. I have not spent a great deal of time looking it over. But I'm willing to keep an open mind to what she said. But I will say, in my opinion, this warrants all of this discussion, warrants independent counsel to be selected, whether it be KP Law or somebody who's a real experts in all of this, okay, to really pour through that all of us feel comfortable with, that I can turn to and raise my issues. Any other member of this council can raise those issues, okay? Because I want to feel like I have an opportunity to share what I have for knowledge on these things and be treated in an open forum for it, you know, and this is a good discussion we're having here tonight. But I think we should really consider making that investment. We send out so many things to independent counsel who are really subject matter experts in these things. Because if we're going to allege and upend decades of rules in this regard, we have to get this right. There's a number of intricacies that I will just say at first glance to Attorney Mantolesky's opinion of April 4th. And again, I have only done a superficial dive. I have not had an opportunity to shepherdize cases and go into all kinds of back into it. But I will say a few different things. First point. One is that if I'm not even sure to the applicability of Chapter 43, Section 18 at all. See, number one thing I would point out to on this law that's cited is these are the plan. There's a number of ways to have a charter, okay? And I'm sure folks are aware of that, right? You can have it by the Home Rule Amendment. You can choose one of the plan forms that are articulated under Chapter 43. You can have a special act charter. That's what Holyoke has, by the way, the Special Acts of 1896. So the question is now, if you read, for example, Chapter 43, Section 45, it says, you know, it raises the question that it says Section 1 through 44G, it questions whether this is even applicable if you don't pick one of these plans. That question would have to be examined, okay? Because we didn't choose one of the charter forms under Chapter 43. The other thing I would mention is it says relative to except as otherwise provided in this section, the legislative powers of the council may be exercised by ordinance or rule adopted by it. And then it speaks to that the council would has the power to establish the rules relative to its proceedings. That's what it says in our charter as well. And our charter doesn't use this language. So the question is, why would the plan form trump the special act form of charter adoption? I don't think that we should just assume that to be the case, okay? Because we have a special act adoption of charter that preceded the 1966 Home Rule Amendment, okay? And so the question of the applicability of these is into question. It would have to be examined. We're certainly not going to solve that tonight. The other thing I would point out, interestingly enough, though, is even if we were to stipulate that 4318 applies, it says all of the members of the council. It answers the previous question that we were just discussing, because we now have a legal opinion from March that says even majority votes are only of those present. So that section that we're hearing in the third opinion conflicts with the second opinion. So that has to be examined, right? So, and oh, by the way, I would also note that if Chapter 43, Section 18 applies, then it also says that the city clerk is elected by the city council. But we know that's not true. Okay. So again, all of this would be deeply have to be examined. I personally think it's a conversation worth having. I appreciate Attorney Mantolesky bringing these issues to our attention. I look forward to working with her on it. I'm happy to continue the dialogue. I have a whole legal pad full of different points I can make here, to the extent you're so patient with me to listen to all of this. I would just say, this won't be solved tonight. I think tonight could be the beginning of the conversation. But I really do think we should bring in a municipal law expert to really dive deep into this. Let's all raise this. Let's get it right. It's very important. I think we all want the same thing. Let's get it right. So I'll stop there. But I think I've said enough for the moment on it. But I do thank you for your time.
Thank you, Councilor Jourdain. Attorney Mantolesky.
Thank you. And I just wanted to follow up because I am 100% sure that when I first spoke, I was unclear when I was talking about the reason behind the difference between the March 2023 opinion versus the June 2021 opinion. And when you are looking at, again, when I had the conversation with Attorney Ball regarding the background of this June 1st, 2021 decision, the only rule looked at was Rule 66. And that, I believe, was the charge sent by the council, was for the law department to look at Rule 66 and what that means. And in that rule, it specifically stated that matters requiring, or that certain matters required a majority of the entire membership. And it made different, it had different statements, even in it, that some of those were those present versus 2/3. So those were all in Rule 66, and that's the only rule that was looked at. I do not believe that when this opinion was done in June of 21, that there was any, reference to, trying to find the one that Councilor Jourdain was speaking about, 30 something, I believe. 35, I believe. I don't think, when this opinion was done in 2021, that rule was asked to be looked at. So I don't think it was. So I think that is why when we looked at the rules from 2022 and we saw that there was the ambiguous language between the definition section and the new Rule 8K, I believe, yes, or Article 8, Paragraph K. There was an ambiguity there with respect to the language because of the voting. Now, if Attorney Ball or her predecessor, Attorney Welloff, did not necessarily look at those provisions because they were not charged to do so by the council back in 21, then, and they were just asked to look at Rule 66, then obviously they would not have had or found that ambiguity. But when we looked at the full rules in March of 2023, we did find that ambiguity, and that was the basis for our decision. And I hope that whether certain counselors agree with that opinion or not, I understand, but that does not mean that it is wrong. And I do believe that there is no conflict between even my recent supplement to the March 2023 opinion, because it is very specific that, as the opinion lays out, that an affirmative vote of the majority of all members. But that means you have to go dive deeper into that, and you have to look at several different statutes as to, does that mean present in voting, or does that mean full membership? And I think that the legislature was abundantly clear when they passed these statutes, that they had specific ones that they did not want to be amended through a charter or home rule. So and that is very clear through case law, and I believe I have stated that in my opinion, but I am happy to have this conversation further. I'm happy to speak to and work with, if the council decides that they want to retain an outside legal counsel, then I'm happy to speak with them about that as well. So I will find that when I did reach out to the city clerk, I was told that Holyoke is actually a Plan B charter, and that specific reference 43 section 18 is to Plan B charters. So that is where that came from, and that was why that was the basis for this supplemental opinion as to why we looked down on that specific statutory section.
Thank you, Attorney Mantolesky. Any other councilors? Councilor Murphy-Ramballetti.
Thank you. And then I see Councilor Bacon's. I guess I just wanted to give my thoughts as a non-lawyer, but also someone who does abstain from votes on the matter of cannabis special permits, and that was as a result of calling the State Ethics Commission and what does that mean, what does that look like, and what should I be abstaining from. I guess I just feel like that I don't think anyone really wants to abstain from votes. Like, that's not why. Like, I think if it was up to all of us, if we could vote on all of these things, we would. But the reason why a lot of us abstain is because you don't want to impact the vote that's being taken one way or another. And so I am just, I have done a little research, not as much as others. But I feel like if someone is abstaining and they're not voting for it and they're not voting against it, and I also just feel like in most cases, abstentions shouldn't affect the outcome of a vote. So I guess just the argument that I was hearing that one might be motivated to abstain from something in order to get something passed, and we might be shifting the culture of the council. I don't think that's why any of us abstain. I think it's because we realize that we don't want to vote for or against something. And as a result, people who are abstaining are not voting. And so then that means, from what I'm reading, is that they're not a present member of the committee. If they're abstaining, it's not the same thing as being out sick, right? If I don't show up to council meeting because I am too sick to show up, I feel like that's like a different thing. But abstaining is saying, I'm not voting one way or the other, and so I'm removing myself from this discussion. So, it just seems like they shouldn't be counted as part of the majority. And after reading both of these opinions, that's kind of what I gathered from that. So I just felt it was, if we're having a nice, wholesome, civil discussion, I wanted to add that in. Thank you.
Thank you, Councilor Murphy-Ramballetti. Councilor Bacon.
Thank you, Mr. Chairman. So I'm not going to try to speak legal language because I'm not an attorney, but I do want to express my concerns about the current opinion as it related to the vote that we took. So there's two major concerns that I have. One is that we had an opinion that was the common understanding that we've operated under for years, that had been used in every single vote except the last vote that we took, that I believe was not legally passed. My other concern is that the department that was giving us the opinion was benefiting from the vote, and I find that problematic. And my other concern is that we had been given information in the past, and I'm not certain whether it was a written opinion or not, so I'm not going to say that it was. But we've been given information that says we certainly cannot contradict state law, but that in our local laws, we can have a more strict rule or ordinance as long as it is not either less than or against what the state law states. So it's been our understanding, based on that information having come to us from our legal department in the past, that our rule as it was written requiring the count of the full body, while it was not an exact replication of the state law, is not in conflict with the state law for that reason, that is our local intent, that's how we want to do it, and that's how we want to count our votes, which have been done for many years. And I would reiterate, as a prior speaker has, that we did not change the language of our rules from the first opinion to the second opinion to the supplemental opinion. And if they were reviewed in their totality, it would include Rule 1. And I guess my concrete question for tonight is, what is the ambiguity? Because the only difference I see between Rule 1 and the other rule is one says full and the other says entire. So I would like to understand what the perceived ambiguity is.
That's for Attorney
If
Mantolesky.
for Attorney Mantolesky, if she could.
Yes, no worries. I just wanted to make sure you were ready for me to speak. So yes, when you look at the language of paragraph 8, section K, the language is, if you go to subsection 3, motion that legal form be ordained by a 2/3 supermajority of the full council voting in a recorded roll call vote. So here you have the language full council voting. And when we took a look at the statutes and Robert's rules regarding the language for, or in case law, when something referenced full council, it meant those present and voting. So that was the review of that section of that rule. And then when you look to your definition section, there was that it was supposed to be the entire membership. So that's where you had your conflict there. And it would go, which could leave it to different, I guess, opinions, which we have had right here. And what answer is the right answer? And so when we were looking at this as to, well, okay, one person or one opinion could be that it's full council means present and voting, and because there's ambiguity, where do you go now? And the law department's opinion was that, okay, you go to Robert's rules, you go to statutes, and what do they say? And, when we were looking at it, there were, although I didn't reference it, or that wasn't referenced in the opinion from March 23, but I did reference it in council chambers when this was discussed in front of full council initially, that your rules can't conflict, or your rules are not really what's to be, they're to be governing your own internal procedures for, like, for example, what you just discussed earlier regarding who's getting, what committee is getting what matters, right? That's perfect for rules, right? For city council rules. There's no statutes on that. It's nothing's, and unless it's something's in your charter, that would be a perfect city council rule, right? But when you're looking at things that have specifically been delineated by statute, that say either simple majority, or they say full membership. And I gave some examples also in my new opinion, or in the supplemental opinion, regarding the different statutes and how they say different things. There is only one interpretation that the law department saw that it could have when you have this ambiguity or perceived ambiguity, even if that's not necessarily what everybody agrees with on the council. The law department's view that there was an ambiguity, and you have to go with what your charter or your ordinances or the statutes say versus your city council rules, which are really supposed to specifically just deal with your own internal procedures, not voting requirements.
Thank you. Mr. Chairman, if I could follow up, please.
Yep, go ahead.
Thank you. So to that point, we have had hundreds, if not thousands of votes to pass the first reading, pass the second reading, and ordain. The only thing that changed is we limited a 5-step process and changed it to a 3-step process at some point in our rules changes. However, the descriptor on the voting was the nature of the vote, not who was present to vote, because that was already defined. And if you read that rule, it talks about voice vote, and then it talks about roll call vote. And every action of the council, if you go back in history, will show that that interpretation was counting of the whole body, and that the voting was describing the type of vote, and that it would be a roll call because that was not otherwise required. So in that regard, I think from my perspective, we will definitely have to agree to disagree on that point. I think just from my practical perspective, not a legal one, again, that the interpretation was consistent and evident through votes for years. And this, to me, is really reaching to come to a different desired conclusion. And for the one time that a person has to abstain, for it to cause the vote to pass, which in the history of ever would not have passed because of a legal opinion, not the body changing its rules, I think is exceeded and undermined the authority of the council. It is the city council that is supposed to change its rules, not by opinion relative to the rules, in my opinion. So I just think that I hope that the committee will seek an outside opinion relative to this matter and a reading of this matter that has no interest in the matter, so that we can come to a clearer answer on it, because I'm just not convinced to be more strict in our counting of our votes is a violation of state statute. But again, I don't know. So thank you for your feedback.
Through the chair, if I may just respond to that.
Yep, go ahead.
Thank you so much. Councilor Bacon, I do take some issue with and it may just been the way that it came out, that there was some sort of interest that the law department had that was somehow in conflict with or would have been against something that the council was to be doing. I can't sit here.
Well, maybe I can clarify that.
Okay.
Because I didn't mean it, I don't think, in the way that you're articulating it. I meant that people within the department are benefiting from the change that was made based on the vote. That's what I meant.
I understand that. That's what I thought you meant. And so okay. I think that I do take issue with the insinuation that because there was a benefit to the legal department or the law department, that we would have surmised some interpretation of a rule or provided with a legal opinion to the council just for the benefit of ourselves. And we and several counselors on the city council are attorneys, and we take an oath as soon as we are sworn in of a duty of candor to any tribunal. And I know whether or not the city council is a tribunal or not, I am employed with the city, and it is my job, it is my duty to give to the city opinions, whether or not it's in my best interest, my superior's best interest, the mayor's best interest, your best interest. The opinion is of what has been surmised versus, or surmised based upon my, or in the law department's review of the law out there at this time. And so I do, you know, take issue with that. Secondly, with respect to the issue, and I know you, I think both Councilor Bacon and Councilor Jourdain brought this up, that this is how our rules have been, this is how we have done it, this is how we have always required it to be done. And I would like to go back to what I said previously, that does not make it correct. And I'm not here to say, you've always been doing it wrong. Like, I'm not here to say, you know, I would never, you know, you guys do amazing work. You are essentially, for a very small stipend, you put in a tremendous amount of time into your legislative duties for your community. So, you know, I would never try to, you know, undermine, you know, saying, oh, well, your rules, that hasn't been right. But there is, I understand that it has been done a certain way, and that you have interpreted your rules as binding. And they are binding to a certain extent with respect to certain items, but not with respect to voting. And I do have additional case law on that, and I'm happy to go into that. But I don't know if this is specifically the time, or we want to continue that conversation, or if we want to, as Councilor, or if the council wants, you know, as Councilor Jourdain has suggested, and as Councilor Bacon has suggested, potentially get an outside counsel to look at the issue too, which again, you know, I'm not, and if I were to be trying to say that the city council, you know, needs to do this just because, you know, it's to the benefit of my department, among other, you know, 50 something employees of the city, but I would not be so willingly or voluntarily putting myself and my legal opinion out there for peer review, essentially, right? So I'm happy to do that because I do have full faith and confidence in my opinion, or I would not have given it to you. And honestly, sometimes you could have a 2/3. So, for example, and I know we're going on a while, but you know, there are different statutes and that's on the second page of my supplemental opinion, that require 2/3 of the entire membership. There's other statutes that require 2/3 vote, members of the council present and voting. And there's other ones that require 2/3 vote that have no qualifying language. And so when you're looking at these different statutes, we have to make sure that our charter, our ordinances, our city council procedural rules are not in conflict with these provisions. So for example, there is charter amendments, right? Under chapter 43B, section 10, which again applies to all charters. That's a 2/3 present and voting. So your rule says or under some counselor's review of the rules, it has to be of the entire membership. It can't be anything else. It's 2/3 of the entire membership. Then what if your statute says 2/3 present and voting? It has to be the statute. That is the one that has to prevail. So that can be for the benefit of someone or to the detriment of somebody. but I think it is very prudent for the council to really consider what language it wants or it should be having in its rules or the charter or the ordinances to make sure that they are in compliance with city statute. So I would just like to make those couple of differencing, just showing that even like under the statutes, there are some times when it's not full membership, and that it doesn't matter regardless of what your rules say, because your statute requires this. That's why the supplemental came out into when I wanted to have it into consideration for you all, so that when you're deciding where to go next with your rules, we can make sure that they are in compliance. Thank you.
Thank you. And to follow up, hopefully one last time. So when I made my comments relative to my concerns, that's what I was expressing, my concerns with how something appears. On the other point that I was making relative to past practice, I wasn't trying to make a point as to whether, based on the look of today, we have been right or wrong in the past. The point I was trying to make is that I believe our past practice clearly shows the intent of our rule that you are saying is ambiguous, because clearly it was a roll call vote that happened, and clearly we required 9 votes to pass the ordinances time after time after time. So I'm not trying to make a legal argument about whether we were right or wrong. I'm just simply making the point that our practice consistently points to one understanding of the language. Thank you. I'm all set, Mr. Chairman.
Thank you, Councilor Bacon. Councilor Jourdain, your hand's up.
Thank you, Mr. Chairman. A couple additional points. First thing I would tell you is that, this isn't the first law department. We've had many, many law departments. I've had the pleasure to work with many, many people in the law department over many, many years. And we always pass our rules in consultation with the law department. So they're reviewing these so that there isn't ambiguity, okay? So that when Rule 66 and Rule 38, which is now Rule 1 and 8K, were made in consultation with them for the exact same purpose, so that a future law department would not have what occurred in March occur. And I just, I want to believe in the good faith of every person here in this discussion, but I really believe if you gave those 2 rules to any person walking down High Street, you don't need to be a lawyer to know exactly what both of those things mean. It's the 2/3 of the full council, and the other definition says whenever there's a 2/3, it shall be of the entire membership. And that's exactly what the law department said 2 years ago, okay? So they said in the legal opinion of March that the rules changed, but they didn't change. So they obviously knew of the 2 rules when they wrote the March opinion. The point is, they said in the footnote the rules had changed. The only thing that had changed was the numbering. And so I guess independent people will just have to read that. But I've given that, and I've asked people who are completely non-lawyers, and they'll say, what are you talking about? It's obvious that means exactly what that means. The entire membership or the full council. That's not voting and present and voting. And it's quite obvious with that. And that's the way and I guess Councilor Bacon's point is that's the way we've conducted ourselves for eons, that was the case. So, this is a new novel take on it. Appreciate, raising it. We'll deal with this. But as far as, and I think Attorney Mantolesky, I do appreciate, because no one likes to have, and by the way, it wasn't you that signed the opinion, by the way, it was Attorney Ball, not you. You spoke in favor of the opinion of March. You recently, I believe, wrote the April 4th opinion. which I'm still pouring through from last week. But the issue is the optics of all of this, right? Is that one would have to be naive not to see the political dimension. And I've seen this with the law departments, but in particular, this was just so obvious, in my opinion. Here you have the law department lobbying in favor of this ordinance change, will gain additional weeks of vacation time for themselves. The vote, this doesn't get brought up in round one, doesn't get brought up in round two, only after the decision is changed that Counselor Anderson Burgos cannot vote. It totally smacks of, what are we going to do now? Now that Juan can't vote, how are we going to get this passed? Because now they're a vote short. And the mayor and the law department put together an opinion, at least this is the appearance from my perspective, okay, is we're now a vote short. So we're going to say it's present in voting. Okay. And that is because to make a change like this, to not have it done over the weekend before the vote, that opinion, if it was really about the process and about all this, the opinion should have been either the vote should have been tabled and this should have all went to committee and we could have had this discussion. We've come now on, Attorney Mantolesky has had this new revelation that what you've been doing for decades is not accurate. And we now have this new information. Okay. And as a result of that, we're going to need you to change X, Y, Z. But that isn't the way it happened. I had to raise a point of order or it wouldn't even have come up into the discussion. Okay. And that to me, and then the law department has to consider looking at it from what, I mean, their personal financial interest is in this. They themselves should know not to participate at that point. That only spoke to, in my opinion, they should have said, gee, even if they didn't feel it was an actual conflict, okay, which I think one could argue it was an actual conflict because by that passing, they personally benefited from that financially, okay? But let's just say it's only the appearance of conflict. Then they should have said, you know what? We should take this opinion and have it written. We should field this out to KP Law. I believe we're doing some work with them on marijuana and different things, or another independent attorney. And by the way, the law department has done that before. I remember Attorney Barnes had a matter where she fielded it out to an independent attorney so that no one could say, hey, this is us trying to help ourselves. Okay. That to me goes to judgment. I think that, you know, if I were in your shoes, that's what I would have done. Because, I mean, I think this should be looked at independently of the law. I think the law department is so tied to this now that I think for everybody to feel like we're heard and to have this definitively, and that these aren't appointees of the mayor gaining, you know, additional vacation time, paid leave and personal days and all of this that was gained from this, that this really should be reviewed independently by experts in this area of municipal law. It's very complex, I'll grant you that. But if we're gonna make a change like this that everybody can buy into and feel, and this is the other thing I want the law department and why I take this so sensitively. The law department is viewed as the referee in the legislative and executive in our entire purpose. And when we feel that the referee is changing the rules in the middle of the game, okay, that doesn't look right to us, okay? Because you will never convince me that the rule is ambiguous. My name, you know, that's as straightforward as my name is Kevin Jourdain to me. Okay, so that, but we'll just say good people can agree to disagree on that point. But nevertheless, when you're viewed as the referee, you got to go above and beyond. Okay. Like I umpire high school baseball. I'm never going to sit out there and say, you know, kids, it really isn't 3 outs, it's 2 outs. I know it's the 7th inning and I know this vote's about to happen. I'm going to change it to 2 outs. I just wouldn't do that. Okay. And you got to be really sensitive to that point. You know, like you guys play this huge role in all of this. And I don't feel that was handled well, all about that. So it's not, you're all wonderful people. Some of you I know better. I've just had the privilege to meet Attorney Mantolesky, you know, recently at this one meeting. But Attorney Lisa Baugh, I've known for years. Okay. I think she's a great person. She may not think I'm the greatest person anymore, but nevertheless, so I like to take all that piece out of it. I have a job to do here, okay? Just like you have a job to do. And I have to look out for what I really feel after all these years of experience, where the rules come down here and what's in the best interest of the ratepayers. Now, as far as some of these additional points, you know, and I think if we have an independent review of this, my opinion is Chapter 4, Section 6 that was cited in the March 23 rule, that doesn't conflict. See, the other point that's made here is you can't do things that conflict with state law. First of all, I would point out that the charter in and of itself is adopted by the state legislature. Okay, that's an important point that should not be lost in this discussion. Our authority to make these rules all flow from the charter, which is adopted by the state legislature. And by the way, Chapter 4, Section 6 says that unless there is a manifest intent, I'll read it here, unless there is observance would include a construction inconsistent with the manifest intent of the law-making body. That's what the statute says in the preamble to Chapter 4, Section 6. Okay, so what has been the manifest intent of the law-making body? We're not in conflict with the statute because the statute gives us that out. All right. Second point is we've already addressed this in our rules. Therefore, Robert's Rules of Order doesn't even apply because, and I could say a series of things, but essentially, and it's stated in one of our rules as well, the Robert's Rules of Order don't even apply when we ourselves have ruled on it in a rule. That's the gap fill when we don't have a rule on point, because Robert's Rules of Order are extremely thick and we couldn't possibly contemplate every single rule. Okay? So in the event that something we don't address, it defaults to Robert's rules. Next point. Relative to, there was a mention of the Ellison case from 1941. That case is cited in this opinion. I would suggest to you, it isn't even supportive of the opinion. Quite the opposite, in my opinion. Because where there is a statute, the court held there that yes, it is voting present and voting. That is the default. Having said that, in the absence of a statutory restriction to the contrary, we have a statutory restriction to the contrary. Ellison from 41 does not support the law department's opinion. That actually says the opposite, in my opinion. But, you know, again, good people can agree to disagree. I think we need to get to the bottom of all of this. We have a good way to go to get there. I would also say that, you know, we should do an independent review. If we do that, you know, I think it's something everybody can feel comfortable with, and that this isn't political. It isn't because of one issue. And that if we're going to make a wholesale decision like this, change from all these years, that it needs to be really thoughtful and has considered all these points by a neutral party. And we're just not there yet. But these, again, I do appreciate the conversation. Again, I have more points, but I think certainly we've made the argument that this bears a lot more discussion. And I also would say I think it would have also been in the law department's best interest, in my opinion, to carefully consider all these points, not sort of make one legal opinion after another that sort of appears like this is all evolving. Like it looked like it was rushed for March, whatever date that is, we took that vote. Like, why are we even having a supplemental opinion? Like, why wasn't this all considered in the first opinion? It just seems like we're spitting this stuff out as it's coming to us. I think we need to take a step back, have some conversations, and if I can help in that, I really want to, because I care a great deal about this subject, because I want the process to feel like it's fair. And I feel like the rules have changed. And this, in my opinion, is going to set this council way back. And I want to leave with this point. When, in our rules contemplate this, when there's and I appreciate Councilor Murphy-Ramboletti raising this point. We do want everyone to vote. But when you do have a personal financial interest, you cannot vote. That's understandable. That's in our rules. But the point is, when you have personal financial interest by not voting, then, and that's helping to get something passed, that welcomes additional personal financial interest potentially, because I get concerned why we, again, I came back and I mentioned this earlier, why we had these rules on entire membership and full council. Because if you don't vote, it doesn't help pass the item you're not voting on. The classic example is just what happened in March. Because if Councilor Anderson Burgos had voted, it passes 9-4. By Councilor Anderson Burgos not voting, and now changing the rule, it passed 8-4. See, it passes either way. Conflict, no conflict. But if you had actually enforced our rules, then they were a vote short and it wouldn't have passed. And therefore, there was no reward for the financial conflict. And that has been the case in the past. So this is my concern, because if you get enough conflicts, like, for example, we start having maybe city councilors being city employees, and you start getting up, we could get to a point where we're rule of necessity even. And now all the conflicts go out the window and everybody votes. Or you could have the total down, or people not voting, not showing up for the votes. And that concerns me also, because if you have unpopular votes by changing the rule from entire membership, that is going to cause, that is not in the public's best interest to get the total down to 5-2 or 4-3, as opposed to 7 or 9 as it currently is. That takes away from the role of the council and the protections of the public and the public interest. So that's why we got to make sure we really get this right. Thank you.
Thank you, Councilor Jourdain. Attorney Mantolesky.
Yes, thank you. I just want to quickly and briefly address some of these things, because if I did not, then I would not be okay with ending my night tonight without saying this. That, again, Councilor Jourdain, I do appreciate, I do respect your concerns to a point, but I think this continued rhetoric of the department had a financial interest they should never have given this opinion because it helped pass this specific ordinance change. This decision or this opinion had no reference to any sort of specific ordinance change. It was specifically the analysis of your rules, one. And I am getting a little frustrated with that continued notion that is being put out there. One. Two, you made a reference how the law department is the referee. The referee does, and you're saying how the ref's changing the rules, and how I wouldn't, if I coached baseball and I would all of a sudden say 2 outs, you're next side, bottom of the fifth, then that's changing the rules. That's not what a referee does. The referee doesn't make the rules. The referee interprets the rules. So if a ref looked and they saw somebody step on, or thought they saw someone step on the base, and the baseman was getting the baseball in his glove, and they said, oh, he's out. I saw the ball hit the glove before he stepped on the base. He's out. That's an interpretation. And that's what referees do. They interpret what they see. Now, sometimes, those interpretations are disagreed with by other people. And that happens all the time. That's why, coaches are always getting thrown out because they disagree with something the ref made a decision on. That happens all the time. And what came into play was instant replay, right? They wanted to look into it further. And so that's what April 4th was, the supplemental letter. So it is evolving, even though you say that it is not, that it's just some sort of revelation that I had. It is evolving. And we're looking further, we're looking deeper to see what is actually the legal standard here. And if the city council prefers to not have our opinion, or have an opinion as to what could hopefully save the city from legal challenges in the future, then I don't really know what to say about that. But as a law department, we are doing what is in the best interest and what we feel is in the best interests of the city, and what can be helpful to make sure the city is as protected as it can be, and runs efficiently and appropriately as to what is said in the charter and in the statute. And I want to leave on one final thing. You keep referencing your charter, right? Our charter, we have this is what it says, but you're not referencing your charter. You're referencing your internal rules. And there is a case on this, that just because you have the ability to make the rule or make your own internal rules and have your procedures be governed by your own internal rules, that does not mean that you have the ability to make a specific rule that is in conflict with statute. Two completely different things. And that is why this supplemental letter was so important, because under the research that I have done now and evolved into and seen, it doesn't matter even if you had 7-6. Under the statute for ordinance change, you would have passed. And so that you keep referring it back to this specific issue, and it's because of this opinion that this ordinance passed, and therefore there's this huge financial windfall to employees of the city, is just not accurate, because in the end, your rules were not in compliance with the statute. And even if you had only 7 people vote and 6 people voted against it, or with Councilor Anderson Burgos being out, if it was 6-4 or whatever it was, 8-4, it would have passed anyway. I'm trying to get you guys to or not you guys, I'm sorry, that is inappropriate. I am trying to get certain councilors to understand that it is not about this one specific ordinance, and it is not about how we could have gotten this one thing passed. It's about making sure that your rules are in compliance with statute and the charter and how you pass ordinances. And that has happened and it has evolved because of this discussion. And I'm happy to have the discussion continue with any sort of outside counsel, again, that you would like to retain. But I just wanted to, make a couple of last things clear. And that's just my opinion. Thank you.
Thank you, Attorney Mantolesky. Retabling. Again.
Mr. Chairman?
Councilor Jourdain.
Yeah. I'll just stipulate a couple different points. Again, thank you. Appreciate everything Attorney Mantolesky just said there. And again, let's continue to work together to figure this out. I would say that one of the reasons, again, I think we need independent is because I am concerned that the law department is made up its mind on this topic. I do not agree that there is a conflict with the statutes. That is an open question at this point. I would also tell you that we're not, while I also want to correct another point that was made, we're not a charter adopted under Plan B of Chapter 43. I hope you know that, because you apparently said you spoke to the clerk and she said to you, well, we're a Plan B under whatever that chapter. No, we're a special act charter. And now it is true of plans A through F. The one that looks most like us is definitely B. There's no question about that. I don't disagree with that. But we didn't adopt one of the plan forms that is now articulated in Chapter 43. I'd have to go back and research. I'm not even sure Chapter 43 even existed in 1896, to be completely honest with you. I would have to go back and research my law from 1896. Happy to do that at some point. But look forward to working with you. I think you're extending the olive branch to get to truth on all of this, and I want to welcome and accept that. I will do my part in that and work with everybody involved. But I do think it would be extremely beneficial if we had an independent review of the law department on this topic of the rules, especially for something so fundamental about this, and that we each bring information to the table and have an independent review. I do think that would be beneficial for the outcome, and would encourage that. So, but having said that, you've been very patient to listen to my points. I do appreciate it. Thank you.
Thank you, Councilor Jourdain. I will say, I'll be brief, committee. So, Attorney Mantolesky, you said the word frustrated, and that's the word that I had written down before you started speaking, because these both legal opinions have gotten me frustrated. I hear what Councilor Bacon and Councilor Jourdain are saying, that we do technically have two different legal opinions in front of us as far as how voting comes down. So I initially was frustrating, but I think, looking at it, I think your legal opinion went deeper. Since starting here on the council, we've been told over and over again, like, it doesn't matter at the Holyoke level, it all comes down to MGLA, with Mass General Law. So I do appreciate you doing those references in your legal opinion, because at the end of the day, we may have been doing things a certain way here in Holyoke, but it doesn't mean that it was the right way. I just think of, one of the first ordinances that we passed here when I started back in January last year was around putting dogs on leashes. And we had a whole hour or two conversation about should we put dogs on leashes, should we not? And at the end of the day, it doesn't really matter because Massachusetts general law says that we are a state where dogs need to be leashed. So, just using that example into this, where it's like, we may have these rules, but if Mass general law is saying something else, that's what we need to resort to, and that's what we need to go to. So I think this started a bigger conversation. I brought it in today because I think it's an important conversation that needs to be had, and also an important decision that needs to be made, because this affects all voting going forward. We need to decide, what is it that how are we gonna pass votings? It's gonna decide how debates happen. It's gonna decide how there's an election coming up this year. There's so much right now that is opened up between legal opinions and we need to settle this. The one thing I will say is, I keep hearing a lot, the rules did not change. And yes, when I rearranged the rules, it was all about putting in order, putting in groups, but that did change the rules, meaning it made it make more sense to people. It opened up the fact that we have two rules that may actually be contradicting each other, so yes, the language may not have changed, but the setup and the easiness and the way to read it has changed, which brought us to this point today. So with that said, I'm all on board of having an outside source looking at our municipal laws, not just around voting, but looking at our charter rules and our charter in general. I think it's something that Holyoke and the people of Holyoke deserve to be done, ASAP. But that was my point that I wanted to make around these two. So motion to table.
Second.
All in favor?
Aye.
Any opposed? So item 4 and item 5 are tabled.
Take up item 6.
Second.
Okay. Item 6, all in favor?
Aye.
Any opposed? Item 6 is a legal opinion by Attorney Ball regarding council access to legal opinions. There was a discussion a couple of months ago around how we can get access to legal opinions, and this is what the legal opinion came from. I know Councilor Jourdain was the one that asked the question, so I'll let him speak on it. Go ahead, Councilor Jourdain.
Thank you, Mr. Chairman. I guess I just wanted some direction. I thank you, by the way, for putting this on the agenda. It's a really helpful a legal opinion, or more than a legal opinion. It's more of an information request from the law department. We have a couple things. One, we have an ordinance that says that we're supposed to have a designated person for the council. And by the way, we passed this at the request. This ordinance was passed at the request of the law department previously. I want to say it was approximately 2014 when at the request, I believe it was Attorney Kara Cunha who did a wonderful job ably serving us. And we made this ordinance, and my question is, who is that person today? And number two is, when individual members need a verbal opinion or want to talk about something, who is the go-to person in the law department? Is it that I should be speaking to the city solicitor? Is it to Attorney Bissonette, Attorney Mantolesky? Who's going to be giving us our, individual opinions on different things, or just wanting to run questions and issues that I have or other counselors might have? I'd like to know how they see this working. Thank you.
Thank you. I see Attorney Mantolesky, your hands are up.
Hi. So this came into somewhat of some discussion. I believe last week there was some email communication regarding this exact issue, and it comes from an issue with how Municode has been uploaded. So Municode is not up to date, and they have acknowledged that that was an error on their behalf. So they are updating it, but there was an amendment done to the ordinances. It was the 135th Amendment. I believe this was done in 2022, possibly 2021. I don't have the exact dates. It's not dated, but it has not made it into Municode yet, but it has been in effect for a significant period of time. And there was a change that the prior ordinance, and it has a how it reads on Municode, unfortunately, says that there should be a designated city solicitor or attorney for the city council. And that was actually removed from the ordinance because of there will be situations when Attorney Bissonnette is definitely more qualified to speak on something than I am. There's times when I'm more qualified to speak on something than he is. There's times when Attorney Degnan is definitely more qualified, and there's times when Attorney Ball is definitely more qualified, just based upon our various practice areas and the in-depth knowledge that we have on various subjects. So there is the revision provides that there will be a member of the law department that will attend the meetings on request of the city council. So, we're happy to do that, of course. And but there is not going to be a specific attorney actually designated to the city council, because there is the ability of the law department now, which is fully staffed, which is amazing, to have a variety of legal experiences and different things that we're handling at any given time, because there is a significant amount of work that happens in the city, and various attorneys will be working on something at a different time. So, for example, I do a ton of the planning and work with OPED and help with zoning and land use for the law department, but I also help with statutory interpretation. So that's some of the things that you'll be seeing from me appearing in front of the council on more regularly. So different attorneys, again, in the law department will handle different things, but upon request, we're always there. I can anticipate that, probably someone will always most likely be here in case there's any questions that do come up. And when there are questions that come up in the meeting, we're happy to field them to the extent that we have that knowledge at that time. If we do not, then we would request a written request from the council to have a legal opinion issued out, so that we can make sure we're giving the most up-to-date answer to the city council. So, of course, to the extent that, again, we're fielding right now, I can field this question because I know the ordinance and I know the issues behind what happened with Municode. I can field that answer. But if there are questions that need additional fielding and time to research and look into, then we will ask that a request be done from the full council.
Thank you, Attorney Mantolesky. Councilor Bacon, I see your hands up.
Thank you, Mr. Chairman. I'm the one that requested clarity through the email last week, and our city solicitor indicated to me that Attorney Bissonnette would be the primary attorney who would be mostly appearing at city council committee meetings. In fairness to individual counselors who may have questions, I think we need to have somebody who would, generally speaking, be the point person. And I'm understanding from city solicitor, Attorney Ball, that it would be Attorney Bissonnette at this point. That's not to say, of course, if Attorney Bissonnette isn't available, that someone else couldn't answer the question. But that was the clarification that I was given. And I guess I'd be interested to know from Attorney Bissonnette if that's how he's understanding it.
Attorney Bissonnette.
Happy to be the point person for contact on issues from any members of the council. I'm available, and if I'm not, one of the other attorneys would certainly take a call and get back to you with the information. But we work as a team. I will primarily be at your meetings, but I have a number of special projects similar to the sewer contract we just finished, which will contain some good news for you. So if you have questions or comments or just want to chat, feel free. I had a good conversation with the chairman today about some of these issues, and look forward to speaking with all of you. Thanks so much.
Thank you.
Anyone else? I was going to say one last thing. I just sort of channeling Councilor McGivern when he says around legal opinions. At the end of the day, they are just legal opinions. Not to undermine all the work and all the amount of schooling that our solicitors have done, but at the end of the day, again, we are the city officials, we are the elected officials, so we get to decide how we want to implement whatever it is that we want to vote on. But I do appreciate all the hard work that attorney in our solicitor's office is doing, because I know it's not easy. Councilor McGee.
Yeah, and just to follow up, but Councilor Vacan is correct. Attorney Ball reached out in email saying that Mike would be appointed, but if there's others, specific to certain issues, then the other attorney would come in or sub in. But I guess the question I have is, they said there was a change in the ordinance that about the assigning of the attorney. In 2002 or 2001 or 21, sorry. Did we vote on that? On that change would be the first issue. And then the other one would be, I could be wrong, that the council had a say in who would be the attorney for the city council. So I'm not sure how that changed, or nothing against Mike. I'm just trying to go prior to when Kira was here and how that all developed. When did this all change, and can we see that, as well as try and figure out going forward what's the best way to do this?
Attorney Mantolesky, I wonder, do you have information on that?
Yes, thank you. So yes, City Council President McGee, there was, it's 130, the 135th Amendment. I have it here, but again, you're not going to see it, spit it out. But if you look at Unicode, it is going to be different because it has not been updated. And we have been speaking with the city clerk regarding that, and making sure that Unicode is able to continue to help us and get it uploaded timely. But that definitely was not a city error. That was a Unicode corporate issue, that they somehow missed certain amendments. So they are now going through that and updating the ordinances in there. But as of right now, under this amendment, that was, again, the 135th, it was 22 actually in the year 2022. Looks like it was signed and everything like that, and it did remove that language that was with respect to an actually appointed person to the city council. That was removed, and made it more open that someone from the solicitor's office will attend the meeting upon request of the council. And I think then it has become the city's solicitor's office's practice that Attorney Bissonnette be the one to handle that. So of course, yes, he can be your point person, but we are also, as Attorney Bissonnette said, we are a team. And so any one of us can field a question, written question, email question, things like that. But if there's going to be, if Attorney Bissonnette is going to be the one that will be at the most city council meetings, then he should be able to answer questions or field them to someone else in the department as needed.
Thank you, Attorney Mantolesky. Councilor Jourdain, your hand's up.
Thank you, Mr. Chairman. Couple points. I wanted to, one, just say you're absolutely correct, Mr. Chairman, about the point that former President McGivern had made. Again, these are legal opinions. This is the body with the authority. Joe is 100% correct. And I would also point out that, again, with all due respect, and I know they're only human, but we have seen the law department wrong many, many times. I mean, good heavens, we only need to go back to the legal opinion about the adoption of needle exchange in the city of Holyoke, where they swore up and down on a stack of Bibles and the state statutes that the council had no authority to stop it and that we were not the local approving body. they wrote an opinion that said that. Judge Mason, he had a different opinion. Okay. And I could cite other examples where on special permits and all, I mean, just, I've been around a while. I've seen this movie for a long, long time. And the tally sheet, it's not anywhere near to batting 1,000. Let's just put it that way. So that's why when we start, as you correctly point out, something as fundamental as how we vote. This isn't just subject to the newest opinion, okay? Because the quote unquote subject to legal challenge, we've been doing this for an awfully long time running a city council. And yet we've never had a legal challenge to any of our votes. We've had a lot of extremely controversial topics over the decades, and we've never had a challenge on that. Interesting. I would point out too, this thing about Muni Code, Attorney Mantolesky is 100% correct. We've got to get this right. I filed an order a year ago that pointed out just a number of examples of different laws that are laws of Holyoke that are not in Muni Code. I'll give you the most obvious of them all. We passed a charter change to go from 15 to 13 members. That's not even on Muni Code left. We passed an ordinance that says that all licenses have to be approved by the city council. The whole entire ordinance isn't on Muni Code. We passed that like 6 or 7 years ago. I mean, somebody I would encourage, and I know they had been shorthanded in the past, and by the way, this council's been extremely generous financially to the law department to get the flex schedules and the added staff and all of this. We got to get this all policed and work with the clerk's office to get these changes. But I will say to the president of the council, I never realized in that section 135 that was just pointed out this past week that the council voted to remove the power of the president of the city council to appoint one of the attorneys for the city council. We worked a lot on that, Todd, in 2014, and I know you were very helpful in that process too. And to now we had that removed. I would have never voted to do that. So that there's things here that are not getting explained clearly. Because I voted to make that the rule. Why would I vote to unmake that the rule? I was president of the council when that was put in, and we worked really hard with the law department to do that. And to now find out that that was all changed and removed, that was not made clear to us. So I think there's some things we need to fix. You know, we'll get to the bottom of all these things, and maybe we need to file some things to put it back. We'll see. But you know, interesting, good discussion. I guess if we'll start with Attorney Bissonnette, and if not, we talk to Attorney Ball, and maybe she'll field this out to different people. But it is good that, you know, we do have an open door to get opinions, you know, on various topics that come up. So I do thank them. Thank you.
Thank you, Councilor Jourdain. Councilor Bacon? Councilor Bacon? Going once.
Oh, I'm unmuted now. Sorry about that.
No, you're good.
I just wanted to add clarification on the language that was changed. It happened in the context of the reorg of the whole department. And so the focus at the time was on the positions and the hours, and it was a fairly complicated change. This particular change, that of which the most significant part was that the role of the president was eliminated in appointing a person. Otherwise, the language stayed pretty much the same. The original language read that an assistant city solicitor shall attend all regular and special city council meetings and subcommittee meetings as necessary, which remained in place. The assistant shall work with the city council regarding legal questions posed to the law department by the council or by individual council members. Also remain the same. except that it did refer to this attorney in the new language rather than the assistant. The remainder of the language that talked about the appointment of the assistant was eliminated. But that particular portion of the language, to my recollection, was not specifically discussed. It was presented to us in legal form, but my recollection is that we didn't have a lot of discussion about it because we were more focused on the more complex areas of the reorg and other pretty meaty aspects there. But certainly we could take an order and clean it up or correct it or clarify it as members wish. Thank you.
Thank you, Councilor Bacon. Any other councilor would like to speak on this? All I would say with legal opinions is that if we can keep the sport references to like a 0, that would be great. But it's all
Thank you. Some of us are not totally familiar with that. Thanks.
My husband's a huge baseball fan, so that's the only reason I know anything.
Thanks. So the motion was that it was complied with. Did I get a second?
Second.
Okay. All in favor?
Aye.
Any opposed? No. So item 6 is complied with. Motion to
adjourn.
Second.
all in favor?
Aye.
Any opposed? Good night, everyone.
Thank you.
Good night. Take care.
Good night.